Good morning. Welcome back to the broadcast Retirement Network. I'm Jeff Snyder. This is BRN AM for Monday, August 2nd, 2021. And our top stories today: the Supreme Court agrees to hear the Northwestern retirement plan case, and the DOL clears up timing and a lot more for lifetime income disclosures. Joining me now to discuss this and a lot more, Kevin Walsh is a principal with Groom Law Group, an employee benefits law firm based in Washington, D.C. Kevin, great to see you. Thanks so much for joining us on the program this morning.
Thanks, Jeff. It's always good being on. It's always good talking with viewers about retirement savings and, legal developments in that area. Absolutely.
Let's talk about, I know we were going to talk about lifetime income in the second segment. Let's talk about this Northwestern case, because this is a case that I think has gone all the way up to the Supreme Court. I want to get your perspective on this.
Yeah, it's an important case because it's going the distance. It's at the Supreme Court. On July 2nd, the Supreme Court announced that it was going to hear Hughes versus Northwestern. And anytime there's an ERISA case at the Supreme Court, it's a big deal. But this one in particular is a really big deal because it goes to the excessive fee cases, which we've seen for the last 10 years. And it really goes to the issue of what does it take to take an excessive fee claim past the motion to dismiss. So really it becomes, it's what do plaintiffs have to show, or what do plaintiffs have to allege in order to get to discovery? And that's a really big deal because discovery by itself is very expensive to defend. Plan sponsors, plan fiduciaries find kind of the discovery costs can be a lot. And you see a whole lot of cases settle if they survive a motion to dismiss, even if they may be less successful in the merits.
So Kevin, tell us, what does it mean to go to the Supreme Court? I mean, maybe a little bit of a civics lesson, but also how this will unfold and what are some of the steps that we should look for, and where would we find information about this, I guess, besides this wonderful network and the Groom Law website?
So there's two important things. One is, what's the process? How do we get here? And what's this mean? And the second is, what is the exact issue that we think is going to be resolved? So talking first about, how did we get here? Basically, in order for a case to get to the Supreme Court, it has to be a pretty big deal, both to the plaintiff and the defendants, and also to at least 4 justices on the Supreme Court. So the reason I say that is because in order for a case to get to the Supreme Court, you have to have the plaintiffs and defendants basically fight it out at the district court level. They have to then fight it out at the appellate court level, and they have to then say, we're going to ask the Supreme Court to intervene. So you've gone through, 2 layers of courts, and now you're asking a third court to get involved. If you're going to go through that process as the side who's lost at one level or lost at 2 levels, it signals that, this is something that you're going to go to the mat on. Now, it's a big deal to the Supreme Court, too, because the Supreme Court doesn't have to take every case. They get to pick and choose which cases they want to hear. And the rule there basically is that they get a whole lot of requests to hear cases. And then on Friday afternoons, they sit down and they talk about which cases they want to hear. And if 4 justices say that's a case we should hear, then it gets added to the calendar. But the Supreme Court gets, thousands of requests for cases to be heard each year. And they grant, between 60 and 100 cases they end up actually having oral arguments on and actually taking. Process-wise, their term ends. Basically, the last day of this term was when they announced they're going to hear the case. So it'll likely be heard sometime next fall. And then we can expect to have a decision by the end of June of 2022. I know that sounds like a long time, but in litigation is kind of the opposite of dog years. In litigation, getting a decision in a year is actually pretty quick. Now, just pivoting back from that, Jeff, do you want me to talk a little bit about what we think they're going to be talking about?
Yeah, I was going to say, I guess my question to you is, as an astute person like yourself who is, you're an attorney, you represent a law firm, what are things that you are looking at what might come about, and how do you protect yourself as an employer, or what are things that you might need to think about if you're a record keeper, an employer sponsoring a retirement plan? What are some of the things that you might be telling clients?
So if I'm an employer, if I'm a plan fiduciary, the message has always been process. Have a diligent process, evaluate the investment options. If there are other options available, consider those, document why you're doing what you're doing. And this case really is going to highlight how much do plaintiffs have to allege process versus how much they have to just simply point to results. One of the big issues is the plaintiffs here say, look, they included one share class in the plan, and there was a lower fee share class available, slightly lower fee share class. And essentially, this is a question where, can a prudent fiduciary decide that, just the delta between the two share classes, the difference in costs, it may or may not be worth switching. And here the plaintiffs want to say, the availability of a lower cost share class, it shows there was an imprudent process. So I think it's going to be going at, under what circumstances can courts presume that a process was imprudent versus, when do they have to actually say, look, the fiduciary decision-making was flawed because of their process. We could see that issue come up. Similarly, we could see it with, how often do folks go out to bid with record keepers? What type of leverage they use. In these cases, we've seen a whole lot of pleadings where, the plaintiffs say, look, Giant Co. Was able to do record keeping for, X dollars per person. In this case, which is, not Giant Co., record keeping costs, Y dollars and Y is more, or that record keeping was done on kind of an AUM based fee as opposed to a per head fee. And the plaintiffs would like to, create an inference that, those things are inherently can be used to get past a motion to dismiss to show an imprudent process. And we're hoping the Supreme Court clarifies this. One way or the other, it's very helpful to everybody when the rules are clear. I think most plan fiduciaries, most corporate plan sponsors, what they're looking to do is act in the best interest of their participants and beneficiaries. They want to get them to a secure retirement. And if the Supreme Court can provide clarity on here's what you have to do, I think it'd be a welcome development.
Kevin, how much education, if you're a litigant in this, how much education do you have to have around how pricing is determined? Because a lot of people who maybe are, you really can't compare apples to apples, and we're kind of getting into the weeds here because you're an industry veteran and I've been around the block too. Pricing is really based on that particular ecosystem, that level of service, et cetera. How does a litigator or solicitor general, whatever the right terminology is, do you have to be on the Supreme Court? Do you have to be aware of some of that understanding, that terminology, in order to make a decision, or is this really like more of a, hey, did they follow the process they laid out, and if they did, good. If not, bad. Here's what's going to happen.
Well, so the Supreme Court, one thing they're great at is they read everything that's provided to them. And here, by the time you get that level, you've got sophisticated briefs, not just from the plaintiffs, not just from the defendants, but the U.S. government's even filed a brief here. I would assume, or I haven't read all of the briefs yet because there's a fair amount of amicus briefs, but they do go into the idea that, saying that record keeper A costs X and record keeper B costs Y, it might be an unfair comparison because you might be getting very different services with two different record keepers, and you may have two very different plan demographics. That being said, I think the plaintiff side would like to have bright line rules because it makes it easier for them at the outset instead of getting into these factual disputes about whether X was a good service for value.
Yeah. Well, it's going to be interesting. I always like and I don't like that the Supreme Court takes up cases like this, but it raises awareness, just like we're doing here. And anytime you can raise awareness around retirement and fees and what matters, I think that's a good thing for a lot of people, including you and I. Kevin, I need to take a quick break. When we come back, we'll talk about lifetime income disclosures. We've talked a lot this week about that, and we'll talk more with Kevin Walsh when we return. You're going to want to stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings in retirement culturally relevant. But what do you see as a defining issue of the midterms? Especially for the smaller businesses. I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network.
Are you stuck with a low credit score? A credit report and score that's causing you to be denied credit or pay higher interest rates than others for the same things? Then do what Terrence did and call Credit Repaired for your free credit evaluation to help restore your credit.
I started thinking about buying a new house, and my score wasn't where I needed it to be. I called and spoke with one of the representatives, and we just had a good conversation, and I liked what he was saying.
Just one call for his free credit evaluation was all it took to start back on the track to repairing his credit.
I'm seeing the deletions and I'm getting the report, so I know something's being done. It does make a difference to me.
All it takes is one call to get started.
Credit Repair has given me a second chance to have a better credit score.
Don't let a low credit score hold you back another day. Do what Terrence did and make the call for your free credit evaluation.
Call 800-819-4152. That's 800-819-4152. Again, 800-819-4152.
Welcome back. We're talking to Kevin Walsh of Groom Law Group. Kevin, thanks so much for staying with us this morning.
Thanks, Jeff. I always have time for you and your viewers.
Yeah, you and your colleague David Levine are very good about breaking this down for lay people like myself to understand the ins and outs of what's happening in Washington. Kevin, let's talk about lifetime income disclosures. We've talked a lot, including with you and your colleague David Levine, about them this week. Some big news. I want to get some further perspective on what does this mean going forward from a regulatory perspective and also adherence to these rules for some of the major record keepers out there.
So I think the lifetime income disclosure rule it's going to be interesting to see the impact that it has on participant behavior. For the past few years, I guess lifetime income has been an issue for maybe a decade, more than a decade now. One of the big problems that record keepers and plan sponsors faced was that the idea of a lifetime income disclosure is that it's designed to give a participant an idea about if you've got X dollars saved today and you're retiring at a certain date, how much money is this going to mean you can spend each year of retirement? And just doing that, there's two real issues, which is, it's not that year that you're retiring, and we don't know what the market's going to do between here and there, or even in retirement. So there's been a sense that plan sponsors, record keepers, and others want to provide this type of information to participants, but there was always this fear that if they provide this information, and you have a 2008 event, you provide this information, and someone retires early, that you don't want to set participants up to fail by making the wrong assumptions. So the nice thing about what the Labor Department's done is they've come out with essentially rules for here is how you move a participant from today into retirement. Here are the assumptions you make, and essentially they've set the formula for that. So it's helped plan sponsors and plan fiduciaries get to a point where they're comfortable doing this, and it's still a big deal for actual retirement savers. And it's a big deal for retirement savers because, and this is something I overuse, but I look at my 401k and it's the most money I have. I look at like my checking account, I don't have that much money in it. I look wherever else I might have money, I don't have that much money in it. When I look at my 401k account, I look at that and I think, oh my gosh, I could buy a nice new car. That is money that could buy me a great car. And I think there's a lot of participants who look at their account balance, their 401k, and they're thinking, wow, I've got some money here. And some of that is because of the way that it's presented. So when we think about, a savings account, a checking account, whatever you're doing with money, you might be saving towards a specific goal. And once you have enough money in that goal, you might go for that goal. With retirement savings, it's really, what's the income stream that I can get off of the amount of money that I have saved away. So instead of looking at my retirement account and thinking, wow, I can buy a car with it, it's more like, well, if I took out, 3 or 4% of that every year, how much money would I be getting if I took out 3 or 4% of that every year? And suddenly I'm pivoting from thinking, wow, you know what, I can take my foot off the gas. I've got enough money for retirement. And now I'm thinking, I need to save more because, 3 or 4% of car money, that's not a lot of money for me to live off of, from age retirement through as long as I need it.
Kevin, you and I both have lived through the fee disclosure regulations and what they resulted in. Are there some lessons that were learned by our friends? And clearly, there's different administrations, different rulemaking people a lot of times, and decision makers. But it seems like there's been some lessons learned in terms of what the output would look like. And again, very different output. One is fees. One is lifetime income illustrations, but it sounds like by making some of these assumptions, and again, these assumptions don't apply to everyone, but they're assumptions made. Everyone needs to understand them. But is this an example where have been some regulatory lessons taken along the way?
So I think they're getting better at it. But if we think about it, there's two problems. One is that, everybody can come up with something that will be really good for participants to know and understand. There's a whole lot of information that we want participants to know. We want them to understand. We want them to monitor. We want them to pay attention to. We want them to make decisions based on. So it's a balancing act. And you've mentioned things like fee disclosures, quarterly statements, and other things that participants get. And I agree with the Labor Department here that an important piece of information can be, how much lifetime income your 401k account balance is expected to be. But I do think there's a fear that if we only add things, that we're failing kind of the lesson that I learned as a junior lawyer, which is, keep it simple, stupid. Not everybody wants to read a whole lot. And even people who read a whole lot might still get more out of less than, blanketing them with lots of information about their retirement account. I think that's highlighted by, there was a case at the Supreme Court, just bringing it back to the last segment, last year, which talked about quarterly account statements. And I don't remember who, but one of the justices mentioned that she or he doesn't open his or her quarterly statements. So if the Supreme Court justices aren't opening their quarterly statements, then I'm not sure how much good all these disclosures do for your typical retirement saver. I think lifetime income is important, but it might be more helpful if we could streamline these disclosures and hit our participants with, here's what you really need to know, as maybe each plan sponsor does their own segment like this, as an easy way of getting information across, or some simple statement to convey information.
Yeah, I think you're absolutely right. I think this is a really good step in the right direction. Gets people focused on what's important, which is not how much you have today, but how long is it going to go. And we're having these conversations about how long we're going to live. None of us know that true answer, but we do know, based on CDC and other information, that we're living longer. And so that's why this information is important. Kevin, we're going to have to leave it there. Maybe next time when you come back on, we can get an update on your favorite topic, or maybe second favorite topic, missing participants. Kevin Walsh, always a pleasure chatting with you. Thanks so much for joining us this morning, and look forward to talking with you again very soon.
Thanks for having me on.
That wraps up this episode of BRN AM. Have a topic of interest, someone you think we should talk to, drop us a line. And don't forget, for all the information in retirement markets, technology, personal finance, so much more, check out today's edition of our daily newsletter, The Morning Pulse. We're back again tomorrow, so until then, I'm Jeff Snyder. Stay safe, keep on saving, and don't forget, roll with the changes.
Are you being audited, and do you owe the IRS $10,000 or more in back taxes? Is the IRS threatening to take more of your money? Don't fight the IRS alone. The Tax Doctor is here to help you negotiate your tax bill and reduce your stress. The IRS can freeze your assets and seize your bank accounts, but you can stop these IRS actions. The Tax Doctor will work with you using our years of experience to represent your case to help you get the best resolution under the IRS guidelines. Help is here to deal with the IRS to reduce your stress. We've handled thousands of cases, so we know what we're doing. If you owe $10,000 or more in back taxes, do not call the IRS alone. Call a Tax Doctor now for a tax emergency analysis.
Call 800-224-6439.